Now, the previous video was over the right to exclude. This video goes over the right to use. The right to use is not an absolute right. The traditional rule has held that the landowner has broad autonomy to use her land as she wishes. However, there are some exceptions to this traditional rule, and we're going to explore those by looking at two cases. The first is Sundowner v. King, which explores this idea of a spite fence, and then Prah v. Maretti, which looks at the nuisance laws and how that might be an exception to the right to use. Bushnell, who was the owner of Sundowner Inc., sold the Sundowner Motel to the Kings. Then Bushnell constructed a competing hotel called the Desert Inn on the lot next door. Sometime afterwards, the Kings built a structure. It's unclear whether it was a fence or a sign, but what was clear was that it was only 2 feet away from the Desert Inn. And it was long enough and tall enough that it blocked out the light from about 80% of the motel rooms. So here's a picture so you can see how close that wall was to the Desert Inn and how it may have obstructed some of the light and air that would be able to go into the motel rooms. So Sundowner Inc. sued the Kings on the theory that this was a spite fence. Now, Bushnell was seeking damages and an injunction to get the Kings to remove the structure. The district court found that the Kings had erected the structure out of spite, and also that it had violated some of the municipal codes. So the trial court ordered that the Kings reduce the height of the structure. The Kings appealed the judgment that were entered against them, and they claim that the trial court erred both on its findings of fact and on the application of the law. So the court applies the modern rule for spite fences. Under the modern American rule, one may not erect a structure for the sole purpose of annoying his neighbor. Now, after applying the rule to the facts, the court has a pretty narrow holding. They hold that no property owner has the right to erect and maintain an otherwise useless structure for the sole purpose of injuring his neighbor. Let's explore that holding. So my first question to you is whether or not the actual intent of the King should matter in the current case. And broadening the question a little bit, should intent matter in spite fence cases in general? My next question is, what if the fence has some useful purpose in addition to harming the neighbors? Would it then meet the Sundowner test? The next case reviews another common law doctrine that restricts the owner's right to use a land, and that doctrine is called nuisance. To have a finding of private nuisance, you need to show that the act was intentional, non-trespassory, unreasonable, and a substantial interference with the use and enjoyment of the plaintiff's land. Courts have found that it would be unreasonable if the gravity of the harm outweighs the utility of the actor's conduct. The facts of the Prah v. Maretti case are as follows. Prah's home had a solar panel on the top of his roof, and that solar panel relied on sunlight in order to provide heat and hot water for his home. Maretti bought the adjacent lot, and he wanted to build a home. But as designed, the house would block some of the sunlight and would greatly decrease the amount of solar energy that Prah would be able to get from his solar panel. I'm going to show you a picture of the proposed construction. These are modern photographs of Maretti's house on the left and Prah's house on the right. And here is a diagram of how the construction of Maretti's house would block part of the solar panels on the roof. So the sun came in from the south, would hit on Maretti's house, casting a shadow, and it would greatly cause the solar panels to produce less heat. So Prah asked Maretti to move his house before it was built. Prah had asked Maretti to move his house several feet away to the south, but Maretti had refused. So Prah sued in nuisance, seeking to stop the construction of Maretti's house. But the trial court denied the injunction that he was looking for and allowed Maretti to build the house, which then ended up, as I previously said, decreasing the amount of energy that Prah's house could generate. So the plaintiff presented three theories, legal theories to the court. We're going to focus on the first legal theory, which was whether or not the construction of the home justified a claim for common law private nuisance. So the court applied a rule that's similar to the private nuisance rule that we outlined earlier in this video. And the rule was when one landowner's use of his or her property unreasonably interferes with another's enjoyment of his or her property, that is said to be a private nuisance. Again, when one landowner's use of his or her property unreasonably interferes with enjoyment of his or her property, then it is said to be a private nuisance. The court says, and I quote at the bottom of page 75 of your textbook, although the defendant's obstruction of the plaintiff's access to sunlight appears to fall within the restatement's broad concept of private nuisance as a non-trespassory invention of another's interest in the private use and enjoyment of land, the defendant asserts certain defenses. Basically, what the defendant asked the court was to consider his right to develop his land as superior to the right of his neighbors to get sunlight. The court, however, is hesitant to take this position. They review the case law and opine that earlier courts have made decisions to provide broader protections for a landowner's access to his property over a neighbor's access to sunlight based on three policy considerations, which the court says are no longer as relevant as they used to be. The first consideration that they cite to was the right of landowners to use their property as they wish, as long as they did not cause physical damage to a neighbor. The second policy consideration was that that courts used to rely on to justify the preference for a landowner's right to use was that sunlight was beneficial primarily for aesthetic purposes. The third policy consideration that courts used to rely on was that society had a significant interest in not restricting or impeding land development. So the court in this case considers those three policy considerations that used to be the primary considerations for courts ruling on case scenarios similar to this one. And they concluded that these three policies were no longer fully applicable anymore. They weren't as relevant now as they used to be. And then they argued that social priorities now would first suggest that there has been increased regulation in a landowner's use of land, so no longer do landowners have as much freedom as they used to do as they please with their property. The second point the court made was that access to sunlight is no longer just aesthetic, that it has real value in providing energy to the landowner and is a cleaner alternative than other sources. So society as a whole has an interest in encouraging landowners to use this solar energy. The third point the court makes is that the need to develop property quickly is no longer as important, essentially, as it used to be. That there are plenty of available housing, whereas our perception of the need for sunlight has increased greatly in the years since the earlier case law. The court states at the bottom of page 77 that courts should not implement obsolete policies that have lost their vigor over the course of the years. And in doing so, they hold that the private nuisance law that the reasonable use doctrine sets forth in the restatement was applicable to the current case. Moreover, they hold that the obstruction of access to light could be considered a nuisance in certain circumstances, and that the results would depend on the conduct complained about, and the court emphasized that the inquiry would center around whether or not that conduct was unreasonable. Now, the dissent disagrees with the majority's holding in that they do not believe that the policies that previous courts relied upon are obsolete. The dissent also disagrees with the weight that the majority gave to this idea of the landowner's right to use. The dissent argues that it is within a landowner's right to use his property within the guise of any ordinances, statutes, or restrictions, and that it was a fundamental precept of a free society, he writes. The dissent also notes that the adjacent property owner could have prevented the situation that arose in the facts of this case. He could have, for example, purchased the adjacent property to prevent any building from occurring on it. Or he could have taken other actions that would have insulated him from the problem. It was his inaction that led him to be in the position that he was in, according to the dissent. So let's explore. So now I'd like to talk about how far Prah's holding would stretch. Let's look at some problems and ask ourselves, should the court apply the nuisance law in these circumstances or not? So the first question is, let's say A constructs a windmill in her backyard to generate electricity. B now proposes to build a home on his adjacent lot, which will partially block the flow of wind. Should the court apply the nuisance law to the facts based on Prah? The second question, city builds a new home with a large south-facing windows. The windows function much like a greenhouse, and they trap warm air inside, and they reduce C's home heating bills. They also provide a lovely view of the countryside. D now plans to build a home on her adjacent lot, a lot which will partially block the sunshine from C's windows, and it will also block the view. Should the court apply the nuisance laws in this particular circumstances?